might, but we're not going to. We've got these 3 bill hearings, and I think that'll probably fill up most of our time. So we're going to go with the 3 bill hearings for today. Okay, and we will start with Senate Bill 30, and I will ask Jason Thompson, our reviser, to give us a bill brief on that.
Thank you, Madam Chair. As you mentioned, Jason Thompson, Revisor's Office. Senate Bill 30, as introduced, comes to you via the Senate Judiciary Committee, and it passed the Senate 40-0. This is the bill that requires the Secretary of Labor to conduct a state and national criminal history record check on employees who have access to federal tax information that's received directly from the Internal Revenue Service. You can see the first section there is one that was enacted last year, is now at KSA 22-4714. This is the list of what criminal history records are given to agencies when they conduct a criminal history record check. The particular amendment here is in subsection B5, which begins on the bottom of page 2 and then goes on to page 3 is where the amendment is. The records received under this subsection are adult convictions, adult non-convictions, adult diversions, and juvenile adjudications. And you'll notice that the information is provided in the amendment here to the Secretary of Labor for employees as defined in the next statute we'll talk about in connection with such employment as described in the next section we'll talk about here. So it's limited to those employees and that information that you would receive. Section 2 then amends KSA 75-5702. It's a statute that authorizes the Secretary of Labor to hire and appoint employees. The amendment there is on page 8, the final page of the bill. So there's a new subsection that's added that basically says the Secretary of Labor is requiring employees who have access to federal tax information received directly from the IRS to be fingerprinted and to submit to that state and criminal history record check that we just talked about in section 1 of the bill. And as used in the subsection, you see employee there means a person who has applied for employment or is currently employed with the Department of Labor and who has been granted access to that information, that tax information. It would take effect on July 1st if adopted, and I'll answer questions.
Okay, thank you, Jason. Committee, what questions do you have for the reviser? Okay, seeing none. I think everyone's very clear about what this is about. Okay, I will go ahead and call our first proponent, Bob Stewart from the KBI. Welcome to our committee. Thanks for being here.
Now I'm on. Madam Chair, members of the committee, thank you for having me. My name is Bob Stewart. I'm the executive officer at the KBI. I want to provide you just a very short back history of some of this. We obviously are in support of this legislation. Last year, we came before you, for those of you that were on the committee, with the complicated first step, which was at the time Senate Bill 491. The issue was and is, Kansas has 77 different statutes that cover background checks. 55 of those cover fingerprint criminal history checks. In order to get valuable information from those criminal history checks, we don't just want Kansas state information, because the KBI could do that very easily. We also want surrounding states and what the federal government has. In order to access that, that of course goes through the FBI. And the FBI in recent years has changed their standards for what they will allow states to do and turn on the switch, so to speak, to allow us to get that information from our fellow states and from the federal government. That's what caused 491 to come into existence, so that we could try to standardize all of that and put it in language that we believe the FBI will accept. What you hear before you is a trailer bill to fix some more of those. We did not catch all 55 in the first year, and quite frankly, we're probably not going to catch them all this year either. I know there's this legislation. Department of Commerce has a bill out that is trying to fix it as well. So that's what the issue is, and certainly as it stands by itself, the KBI is 100% behind Senate Bill 30. The Department of Labor worked with us very closely, worked very hard themselves to try and get this in front of you, and we want to be supportive. At the same time, I would ask the KBI, if you determine to work this bill, the KBI would ask to maybe catch a couple of those by way of an amendment. There are two other that are particularly important to try and move relatively quickly. The Attorney General has some language that needs to be fixed, and the Office of the State Bank Commissioner has some language that needs to be fixed. So I will be asking potentially for an amendment that would include language to cover both of those as well. Seeing as how you've got a large crowd and 3 bills today, I will be quiet and answer any questions should you have them.
Okay, thank you. I think we'll go ahead and hear from Ms. Schultz from the Department of Labor and then see if any of the committee has questions for either one of you.
Yes, ma'am.
Thank you. Okay, so I'll call Amber Schultz from the Kansas Department of Labor. Thank you for being here. Welcome to our committee.
Thank you, Madam Chair. Appreciate it. Members of the committee. Secretary Amber Schultz, Kansas Department of Labor. We've provided you with written proponent testimony, so I won't belabor it with any more details, but I'd be happy to stand for questions if you all have any.
Wow, that was that was fast. Okay. Okay, committee, do you have any questions for Mr. Stewart or Ms. Schultz? Representative Carmichael.
Thank you. I'd be remiss if I didn't say hello, Madam Secretary. Nice to see you, but my questions are not for you. Mr. Stewart, might I inquire, Mr. Stewart, about the nature of the additional background check authority that the Attorney General seeks and that you may suggest that we should offer an amendment to this
It's
legislation?
comporting language, basically, but it's down the line of where they have the authority to do backgrounds in firearms licensing, concealed carry area, their general background authority in that realm, not in their employment realm, in their work regarding oversight of that program.
So is it all confined to the concealed carry permit program?
Most of the languages, I think there's some technical corrections in there as well. As we're going through these one by one and realizing we're trying to get it all to say the same thing, there is some that goes a little bit beyond that, but generally speaking, it's within the firearms program.
The reason I ask is I just don't want to find myself surprised by, a balloon amendment that talks about things that we haven't discussed here in committee and why it's necessary and why it's a good idea. I don't know if there's anything more that you can say to educate us, but once you know what you need, if time permits, please try to let me know what it is so that I don't react badly. Thank you, Madam Chair.
Understood, sir.
Very good. Okay, any other questions, committee, or either of our proponents? Representative Schreiber.
Thank you, Madam Chair. Mr. Stewart, you mentioned that a similar bill was introduced in Commerce. Is it similar to this, or does it have something else in it?
It is very similar. It is correcting the Department of Commerce's authority that they had, and I think it's expanding it a little bit based upon some things that happened this summer regarding an unfortunate event.
Yeah. Would this bill cover that, or?
No, sir.
Oh, it's different. Okay.
Yeah.
Thank you. Thank you, Madam Chair.
Any other questions? I do have a question. You mentioned that, the 55 statutes regarding fingerprinting. And so how many more are there that we might be expecting, or is this, do you have any numbers, any thoughts?
We have not had any agencies come to us this year like we did last year. We're just a little skeptical that we caught them all. We think we've gone through. Of course, we thought last year we got them all and we didn't. But, so I leave that open that there's a possibility that there's still a couple we missed. And then a hearing like this will trigger somebody watching or listening. It's like, oh, we need to double check ours and see if there's another one. So it's possible, but we don't have a number.
Okay. All right. Thank you. Okay, committee, any other questions for either of our proponents? Okay, thank you. Appreciate it. So, committee, we don't have any written testimony or opponent or neutral. And so with that, I will close the hearing on Senate Bill 30. And I'll go ahead and open the hearing on Senate Bill 128. And again, ask our revisor to give us a brief. Thank you.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. Senate Bill 128. This one is again, as introduced, comes to you from the Senate Judiciary Committee, and the Senate passed it 40-0. This is a bill that creates exceptions to certain mandatory reporting obligations for licensed social workers, but only when they're working under the supervision of an attorney. you can see there's a number of sections in the bill, and we kind of broke this down in the bill brief that one of my colleagues did on the Senate side, and it's very good, so I just copied it. There are 3 sections that mandate reporting by certain persons, and in this case, we're just talking about the social workers that are mandated under those sections. And then there are 3 sections that prohibit an employer from taking certain actions against an employee because of their mandated reporting requirements. And again, we're only dealing with the social worker aspect of those 3 statutes. And then there's a 7th statute that's about confidentiality and social workers specifically. So we kind of broke that down in the bill. Sections 1, 3, and 5 are those mandated reporting statutes. And what's added in those statutes is a provision specific to licensed social workers that says they're not going to be required to report when they're working under the supervision of an attorney and the reason to suspect that harm is occurring from the particular abuse or financial exploitation that triggers their mandated reporting requirement arises solely in the course of the attorney's representation or prospective representation of a client in a civil, criminal, domestic, or juvenile matter. So again, social worker working under the supervision of an attorney comes to find something that would otherwise be required to be reported, but that reporting requirement will not have to occur if it arises solely under that relationship with that attorney, because it's attorney-client information, it's otherwise privileged, et cetera. So, and the proponents will get into kind of the rationale, but that's the exception that's created. And then again, sections 2, 4, and 6 are statutes that prohibit employers from taking certain actions because an employee has a mandated reporting requirement. And that same sort of language is added to those 3 statutes. So I won't repeat that, but that's why it's in there kind of in pairs, right? Sections 1 and 2, 3 and 4, 5 and 6. And then section 7 is a specific statute for social workers. Currently, it provides that information acquired from a person by a social worker is generally confidential unless certain exceptions apply. There's no confidentiality for information that's required to be reported to a public official, though. And so then there are some other exceptions, and it gets kind of complex in there. But the main thing of the bill that I would emphasize is that it specifies a social worker would not be required to testify on that acquired information that they receive from working under the supervision of an attorney and in one of those civil, criminal, domestic, or juvenile matters. It would also provide an exception for information that's not generally not considered privileged by reason of it being reported to a public official, and say that information acquired by a social worker while working under the supervision of an attorney would still be privileged. So sometimes you would lose the privilege by reporting it, and there's an exception kind of created here. So that's what's in section 7. Again, all kind of related to that idea of social workers working with licensed attorneys and that relationship being the key to all of this. I'll mention that it would take effect on July 1st if adopted, and I already mentioned the Senate vote and how it got here. So I think that's good. I'll stand for questions.
Okay, thank you. Committee, what questions do you have for the revisor? Okay,
All right.
again, another excellent job. Thank you, Jason. Okay, we will now call the proponents. We have 7 proponents. I'm going to ask you to try to keep your testimony maybe 2 or 3 minutes, or say what you would like to say, but try not to repeat everything from each other, but want to hear what all the proponents do have to say. And then we'll save questions for the end of the proponents. So first I'll call Heather Cessna from Kansas State Board of Indigent Defense Services. Welcome to our committee, Heather. Nice to see you.
Thank you very much, Chairwoman Humphreys and members of the committee. My name is Heather Cessna. I'm the Executive Director of the State Board of Indigent Defense Services, and I am here today as a proponent because we asked for this bill, specifically because as we have been trying to expand our holistic defense services and incorporate social workers in our defense practices, we came to realize that there was a conflict in the statutes on the mandatory reporting requirements of licensed social workers and the confidentiality requirements for attorneys, which is the cornerstone of the attorney-client relationship in those cases. So normally a attorney who has staff working underneath them or is supervising staff to work on a case, their duty of confidentiality extends to all of those staff people. And so what we tried to do was help craft a very narrow exception to the mandatory reporting requirements to basically try to alleviate that conflict between the attorney-client confidentiality relationship requirements and the mandatory reporting. I'm not going to go into great detail about why some of this is necessary because we do have a lot of proponents that I think are going to be able to share the specifics of this. I did want to take a brief moment to point out that there's a couple people who submitted written-only testimony. Michelle Ewert, who's the director of the Washburn Law Clinic, talks a little bit about how this would impact the university practices at the law schools as they're doing clinic work. And she was able to testify at the Senate side, but was not able to be here today. So if you have a chance to watch her testimony from the Senate side, I would encourage you to do so. I was also going to point out that one of the written proponents that's not able to be here today in person is Becky Fast, who is the Kansas chapter of the National Association of Social Workers. Representative is also a proponent testimony. So we worked with social workers to try to craft this very narrow exception in order to sort of solve the issues that we saw with the client confidentiality, but also meeting the requirements of the social worker needs otherwise. So I will obviously be happy to stand for questions after you've heard everyone else's testimony, as you said, but I will go sit down so other people can talk. Thank you very much.
Yeah, thank you, Heather. Appreciate that. Okay, I'll now call Karen Levy, the Kansas State Board of Indigent Defense Service also. Welcome to committee.
Good afternoon, committee. Thank you for having me here. My name is Karen Lev. I am the Assistant Director of Special Projects at BIDS. I've previously submitted written testimony, so I will try my best to keep this brief and highlight the importance of the role of the social worker on the legal defense team in support of this bill. By way of background, I am an attorney. I am also have a master's of social work, and I held a license in social work for about 7 years. Before joining BIDS, I worked as an attorney at the Bronx Defenders, which is a holistic public defense organization that utilizes an attorney and non-attorney team model in representing clients. So I regularly represented my clients on these legal teams alongside licensed social workers. And the purpose of these teams is that having these teams instead of just a lawyer is to provide this specialized client-centered defense that targets not just the case that brought contact with the legal system, but targets the underlying factors, the social and economic factors that got the client to this point. And this type of holistic team-based defense has been shown to improve case outcomes for clients and specifically to help reduce recidivism so that the client does not return to the system. Having a social worker on the legal team was, in my experience, vital to the client and legal team as a whole. Social workers on the legal team enhance client advocacy and allow attorneys to better and properly serve their clients. They are adept at using empathic interviewing and have strong assessment skills that allow them to get to know clients in a way that their attorneys simply cannot. The information that social workers gather help clients advance their legal goals through mitigation or release planning, amongst many other things. Further, social workers have specialized education in mental health, addiction, and assessment and they use those skills to help the lawyer understand the needs of the client and then have the knowledge and connections to community resources, services, and supports that then help the client address those issues. As you all are aware, the attorney-client privilege is vital to the attorney-client relationship. It exists to encourage full disclosure. But if a member of that team who shares that singular goal of representation has a different disclosure obligation, it creates confusion and threatens to disrupt that important relationship. So a client may be confused about who on their team they can speak to, who they can tell what to, and frankly might cause them to not talk or be open in the way that clients should be able to speak with their attorneys. It causes a breakdown within the legal team and can ultimately create in the client a choice of not working with the social worker at all, even though there might be substantial benefits to their legal case. So I will conclude by just saying that a social worker on the legal team is a vital part of the advocacy effort of the attorney, and they should be able to fulfill those obligations to the client accordingly. And this exception allows legal teams to function properly, provide strong legal representation and advocacy by allowing social workers to do their work more fully in support of their clients. Thank you for your time, and I'm available for questions.
Okay, thank you so much for your testimony. We'll now have Marilyn Harp, private citizen. Marilyn, welcome to our committee. I think this is the first time we've seen you this year.
Yeah, thank you very much. Thank you, Madam Chairman, and the rest of the committee. I'm here in full support of Senate Bill 128. I'm Marilyn Harp. I am the former executive director of Kansas Legal Services, and so I want to speak to the civil side of this because what you've been hearing is a bit from how it would benefit people in the criminal environment. I have a Bachelor of Social Work degree that I received, but never became a licensed social worker because I knew I was going to law school, and frankly, taking the exam would set me up for the potential of not being able to even complete law school because I might, in a clinical setting, violate my social work, violate one or the other very competing obligations. Many years later, in my work at Kansas Legal Services, I set up a program with DCF, one of their array of Family First programs, and really a great prevention program called the KLS Parent Advocate Program. Under that program, DCF, who might do a home visit and find a situation where children are not they're not ready to go into state custody. The situation's not to that level, but perhaps could ultimately get there. DCF can refer those kids in certain counties to a team of Kansas Legal Services employees. And those teams really should be lawyers and social workers. Unfortunately, they are not. Because of this bill, KLS was never able to hire licensed social workers in those roles. We got lucky once in that we found an employee and hired her who had a bachelor's degree in social work, but was delaying taking the exam until she finished her master's degree. And since she was a single parent, part-time student, it was about 3 years that we were able to employ her, bringing the social work skills, but not the obligation to make reporting. So this bill would solve those kinds of problems and allow this to go forward. I also mentioned the issue of social work students who don't have the opportunity now to train in a legal environment because of this bill. So since 2001, when the Attorney General determined that lawyers must either refrain from involving social workers to the detriment of clients or employ social workers and make informed disclosures to all clients, no law practice has been able to have lawyers and have social workers involved, and I think that should change and would support this bill.
Okay, thank you. Thanks. If you can stay for questions, that'd be great. Okay, now we'll have James Pratt from Pratt Law, and I think it's WebEx. And you're not Cole. You're what's your name? Nat. And so, do we have the person on WebEx? Okay, James Pratt. Great. Thank you so much. James, can you hear us? Okay, thank you.
I can.
Yep.
Can you hear
Welcome to
me?
committee. We
Thank
can
you.
hear you. Mhm.
All right, my name is James Pratt, and I'm a solo practitioner with Pratt Law LLC here in Wichita. And I'd like to kind of look at this more of a micro issue than the macro as a holistic practice. I've been a criminal defense attorney for almost 30 years, and in the state of Kansas, at sentencing, the judge gets a pre-sentence report which basically lists the crime, severity level, and my client's criminal history. They don't get anything else. They don't know anything about my client other than what they may read in an affidavit. So the only way to get information to them is through me. And the best way that I have found to get information from my client is to do interviews which law school does not train us for. They will teach us the law and how to analyze the law and the facts, but they do not teach us how to analyze our clients. A couple of years ago, I started looking into this, seeing if I could get a social worker involved, and I ran up against this issue that we're trying to take care of today, is the reporting requirement. I even thought about using student social workers, but then I learned that they have to be supervised by a licensed social worker while they're doing social work activities. So that was not an option. I did find an interpreter that I've used in several cases who had a bachelor's degree in social work, but who has never applied for licensure. So I've been able to use her simply to do these interviews to get information that is vital to me in representing my clients. A lot of people, a lot of attorneys will say that it's our job to tell our client's story. I like to think of it more as it's our job to humanize our clients to two people, the judge and the prosecutor, who only know about them from something that may have happened on the worst day of their lives. And the best way to do that is with these focused interviews with someone who is trained to do them, with somebody who is also trained to perhaps take the information they receive to the next step as far as referrals for mental health care or drug abuse or things like that. So in my practice, I try to use a unlicensed social worker as often as I can, but it's just there is a lack of training there and a lack of resources. And you also get into obviously the practicing social work without a license. So that's why I would encourage this committee to pass this bill and hopefully get it past the House so the governor can sign it and we can begin using social workers in this very important aspect of criminal defense. Thank you, and I will stick around for questions.
Okay, that sounds great. Thank you so much for your testimony. Okay, we now have also on WebEx, Tim Burdick on behalf of Melody Brannon, Federal Public Defender. And Tim, can you hear us?
I can. Can you hear me?
We can, and we can see you also. So welcome to committee.
Thank you. Good afternoon. My name is Tim Burdick. I'm an assistant federal public defender in the District of Kansas. I've been a public defender for over 25 years. I've served thousands of clients. And the bedrock of my service to my clients and my representation of them, and really the bedrock of the entire legal system, is the attorney-client confidentiality and loyalty. It comes down to trust. My client needs to trust me in order to get the best result. My client needs to trust the team that works with me in order to serve them the best. Every member of my team is bound by my obligation of confidentiality and loyalty. That is, investigators, paralegals, even law students, save one, and that currently is a licensed social worker in the state of Kansas. I don't think that the statutes that the Kansas legislature created for mandatory reporting contemplated such a conflict to arise between attorney confidentiality and social workers' mandatory reporting obligations. It just simply didn't account for it. And so what we're asking for is a very narrow fix. Increasingly, we have more clients that suffer from mental health issues and substance use issues, and they're swept up in the criminal justice system. It's important for us in our representation in a holistic manner to incorporate social workers into our representation. You see, we have clients that are under the court supervision, whether it be pretrial release or on supervised release, which is simply like probation after someone is in prison. And we need to help them to abide by the conditions of supervision, and we need to help them to reintegrate into society. And a licensed social worker is the person that can do that the best. They can connect our clients with community resources. This makes the community safer. It reduces recidivism. It keeps people from going back to prison and increases the likelihood of their success. Social workers also support not only our clients, but their families and the community as a whole. The work that social workers do for us saves taxpayer money. Imprisonment is expensive, and community-based treatment costs a fraction of that. Our ability to have licensed social workers on our defense teams makes government more efficient and our legal system more effective. But for the social workers to work on our defense teams effectively, it all requires trust. Our clients must trust that they can be honest and open with the team, and they can be honest and open with social workers so that we can adequately address the issues that they need addressed. Now, our office has up to this point come up with a temporary workaround. And what we do is we ask our clients to sign a waiver. In other words, we say to them, if you want to work with a social worker, you will have to waive confidentiality. But that's just not sustainable. It's confusing to clients to know who's they can speak to and who they can't. It's disruptive in our relationship, and ultimately it's unworkable. We recognize that there's a second option, and that is to try to use unlicensed social workers. But we want licensure, we want professionalism, we want standards, guardrails, and continuing education for our social workers on our team. And I think that the state of Kansas should want that as well. We want a licensed social worker so that that social worker can supervise other social work interns in our office and help with representation. We're afraid that the use of unlicensed social workers will simply discourage licensure in general. Again, Senate Bill 128 is a very narrow exception. Mandatory reporting makes complete sense in many contexts for social workers, but in this narrow field, with this narrow conflict, we believe that it doesn't. And we believe that Senate Bill 128 offers a simple and circumscribed solution. In closing, our practice of holistic defense provides the best outcome for our clients. And in turn, successful clients, which is our goal, is the best outcome for the community. And licensed social workers are an integral part of that. Thank you.
Okay, thank you. Mr. Berg, I do have a quick question. Was that, we have the written testimony of Melody Brannon. And would you, if your testimony varied from hers, maybe you could also provide the written testimony yourself. I just noticed it didn't, we have hers. And then
Yes.
if yours followed hers, I couldn't follow it exactly, but if yours is different in any way, if you could also send that to us, that would be great.
Certainly.
Okay, thank you. Thank you. Okay, and now we have Noelle O'Neill, also from the Federal Public Defender's Office. And welcome to committee.
Is this on?
I don't know, is the light on?
Perfect. Okay. Chairperson Humphreys and members of the committee, my name is Noelle O'Neill, and I am a licensed social worker at the Kansas Federal Public Defender's Office. I appear before you today to explain how the proposed Senate Bill 128 would impact social workers such as myself. Before I get started, I think that it's important for you to hear a little bit about me and my background. I grew up in the small community of Norwich, Kansas. When I was in the 3rd grade, my teacher, Ms. McDaniel, asked my fellow classmates and I, all 16 of us, what we wanted to be when we grew up. When it was my turn, my response was a police officer. She wrote our answers in a notebook that she kept in her desk until we graduated. The 18-year-old version of myself did not venture far from the response that my 9-year-old self gave. I was headed to college to pursue a degree in criminal justice. My senior year, I was an intern in a probation office, and this is where my career changed course. I recognized that there were individuals who were on probation who had been released from prison and struggled to meet the requirements of that probation. Not because they didn't want to succeed, but because they were dealing with underlying issues that had not been addressed. In 2017, I started my career at Wyandotte Mental Health Center. I worked alongside individuals who were on probation, but who also struggled with mental illness. I was a part of the team that established the mental health court in Wyandotte County, and I was the case manager for the first ever graduate of that program. In 2022, I got the honor of being another first. I became the first social worker hired by the Kansas Federal Public Defender's Office. In this role, I support clients who are at risk of going back to prison by connecting them with supports, including mental health treatment, substance use support, and housing assistance. Another component of my job is sentencing mitigation. This is the process of uncovering the events that led to an individual's involvement with the legal system. So just like it's important for you to get to know me and what brought me here today, it's important for me to get to know my clients and the events that led them to where they are at. Every day I get the opportunity to hear our clients' stories that are often painful and complex. The skill that it takes to uncover these stories requires something fundamental: trust, the cornerstone of effective social work practice. When clients fear that certain information that they disclose may extend beyond their legal team, it compromises our therapeutic relationship. As a licensed social worker, I take great pride in my profession. Obtaining my social work license required graduating from an accredited university, completing internships in both clinical and non-clinical settings, passing the social work board's master's exam, and my ongoing participation in continuing education programs. Throughout the social work field, because of this high standard of service, licensure is often encouraged. It troubles me to hear that under current law, to effectively serve within the legal defense team, I'm indirectly being asked to give up the very thing that makes me good at my job, my license. If I'm being honest, placing unlicensed social workers in this position raises some concerns about the future quality of our work. Additionally, something I know the committee will consider is the question of risk. While mandated reporting requirements are necessary in most settings, such as schools, the legal defense setting is unique. By having social workers embedded in defense teams, there's actually less risk than there might appear to be on the surface. In the course of this work, much of the information that might typically trigger a mandated report is historical in nature or already documented in police reports and court records. Additionally, many of our clients are either in custody where they pose no risk or under supervision where they are being monitored by an officer of the court. The integration of social workers into legal defense teams represents progress in our legal system's abilities to serve clients both efficiently and effectively. So, just as my early aspirations have evolved and I have found more effective ways to help people, that same system has an opportunity to evolve by allowing qualified social workers, such as myself, to use their skills to create better outcomes for our clients and ultimately our communities. Thank you.
Thank you so much. Committee, now's your opportunity to ask questions of any of these proponents. Let me know. Representative Carmichael, you go first.
Thank you, Madam Chair. And this is for anyone who can help me with the answer to this one, okay? My recollection is that as a lawyer, I was and still am obligated to keep my clients' secrets and confidences that they tell me. However, I think there is a situation where when there's immediate threat to others, if my client tells me I've got a gun and I've had it with my ex-wife and I'm going to go home and I'm going to shoot her and that's going to put an end to this problem, then I probably have an obligation. If not an obligation, I certainly have the option to call the police to try to prevent that from happening. Is there the same sort of, I hate to say get out of jail free card, but is there the same sort of an exemption to the exemption in cases where the social worker in the context of working for the attorney on the client's case becomes aware of an immediate threat to others, particularly kids obviously come to mind?
Committee. This is Heather Sussna. I'm the Executive Director of the Board of Indigent Defense Services. I'm happy to answer that question. So you're right. The ethics rules on confidentiality do allow for the permissive disclosure of that kind of information if it's like an impending issue that could lead to harm immediately. The same version of confidentiality that is applying to the attorneys would apply to anybody on that staff under those ethics rules. I mean, as an employer, I would hope that the social worker would probably have that conversation with the attorney who's the lead of the case, you know, obviously, but it's the level of confidentiality that would extend to everybody under that penumbra, if you will, that will be the same then as the attorneys. So they'd have the ability to, you know, that conflict then is dependent upon the attorney's confidentiality requirement, basically.
I know that's
that
our
answer your
intent. I
question?
just wasn't, yes.
Yes.
I'm just not sure if we'd clearly expressed that, but you all have worked on it harder than I have. My second question, Madam Chair, with your leave it, the reviser may be able to help me with this, but some of the lawyers may as well. As I read the bill, I repeatedly see the phrase, except for information acquired while working under the supervision of an attorney providing services to a client in a criminal, civil, domestic, or juvenile matter, or when a prospective client sought representation and the information was obtained solely in the course of that work under the supervision of the attorney. That looks to me like it would include information that the social worker acquires while working for the attorney, which may not come directly from the client, but may come from other portions of the investigation. Now, I may be wrong about that, but where my concern is when I look at the reviser's memo on page 2 with respect to section 7, it concludes by saying the bill would provide that information acquired by a licensed social worker while working under the supervision of an attorney, and the information is acquired solely from the attorney's client or prospective client in a civil, criminal, etc., would be privileged. It seems, and I may be missing this, but there may be different language in the reviser's memo pertaining to section 7, because it would appear that the privilege only extends to information received from the client. I read the statute itself as broader and extending to information that was obtained solely in the course of that work, as opposed
Could I try to, I'm sorry, could I try to answer that for you?
That's my
Okay,
question.
yes, that's okay.
Mr. Pratt may
Okay.
well know real well about that.
Yeah, so if you would introduce yourself again, please, for everybody.
Jim
Thank you.
Pratt, Pratt Law from Wichita. I think what we're dealing with is two separate issues. Privilege for the attorney only applies to communication that comes directly from the client. Confidential information, which is what's governed by the ethics rules, is any information that comes from representing a client. So I think that's how they're trying to separate it within that framework of the privilege being an evidentiary rule that only relates to direct communication with the client, confidentiality being the ethical rule, which encompasses everything about the matter. I hope that answers your question.
Well, I appreciate the distinction. It's one that we all suffer through when we take the professional responsibility examination or whatever it's called today. But I'm not sure that the language that we're using here, I'm trying to reconcile what I see in the reviser's memo with what I see in the italicized portions of the statute, and I must be missing something. The italicized portion of the bill, not the statute.
Jason, do you have a comment? Yeah, thank you for that. Go ahead.
All right, thank you, Madam Chair. Jason Thompson, Revisor's Office. So, yeah, and this is the danger of, I mean, I'm not going to throw my colleague under the bus, but no, I think obviously you look at the language of the bill more specifically. Our summary, may deviate, but specifically that section 7, The language at the very end on page 11 is, and the information was obtained solely in the course of that work under the supervision of the attorney. So it doesn't, to me, say it has to be from the client. It's from the work with the attorney. So my reading of all of the provisions was that it was broad enough to cover any information obtained, from the relationship with the attorney, more anything confidential rather than privileged, to use the couple terms we were just using. I read it as covering anything, not just directly from the client. And our memo may have not been as artful as the statute.
I read the bill the same way, Madam Chair. I just wanted to make sure that I hadn't missed something because frequently I do. Thank you.
Okay, committee, thank you for that clarification. Any other questions? Heather, I do have one question for you. I'm just curious if now you have social workers on teams, if you're already doing that, or if, I don't think you addressed that particularly.
So we are, sorry, this is Heather Sussna with the State Board of Indigent Defense Services. Thank you, Madam Chair. We do have a handful of mitigation specialists, some of which are not social workers, some of which are social workers that we use basically in this context. There's a couple of them, I think, that are not actually licensed, and then there's a couple that are. So for the ones that are licensed, we are having to do the similar sort of circumstances to what the federal defenders were talking about, where you have to go through a waiver of confidentiality on those cases, which frankly is, as they said, not workable in the long term because the ability of the client to anticipate and understand when something that they're about to disclose is going to trigger that mandatory reporting requirement is, I think, very difficult for our clients to differentiate. And so the tendency, I think, is that if you're, having to make that waiver, you're going to be less likely to disclose things that, frankly, during the course of the representation, we really need to know in order to be able to get the best outcome, not just for our clients, but for the system in general. One of the, as I know some of you have heard when I've talked in other contexts up here before, 97% of our cases end up in pleas in Kansas, of our criminal cases. And so oftentimes what you're talking about is that negotiations with prosecutors and them representing the victims in those cases to try to get the best outcome from what needs to happen in that case, not just necessarily for our client, but from the prosecutor's perspective for the victims as well. And so having all of the information that we need and that disclosure is really important. So we have a few of them. We haven't been able to expand the program as much as we would like because we've run up into this problem. And again, you don't want to necessarily discourage people away from getting licensure for all the obvious benefits from having a licensed social worker. So that's kind of why we brought this bill, so that hopefully we can continue to expand those positions.
Yeah, thank you. That was helpful. And I am curious because we've talked so much about the appropriation side of bids and what you're paying your attorneys. Are those social workers, is that an hourly rate that you pay them, or do they have a salary either on your staff, or how does that work?
So our social workers are mostly going to be hourly rates. They're paid fairly comparable right now because of a lack of other funding, along with legal assistance, although again, that was partially because we were having to look at unlicensed, primarily individuals for those positions. I think as we continue to try to expand that program, we may have to go back for appropriations to try to appropriately compensate licensed social workers in that context better than what we can currently do.
Thank you. Okay, committee, any other questions for any other proponents? Representative Bohai and then Vaughn.
Thank you, Madam Chair. Are other states currently waiving this?
So my understanding is that there are a couple of other states that have sort of similar provisions where there's like a narrow exception, and that's actually where we started with this language, was looking at, I believe it was DC's version of this problem and how they address that in their statutes to try to carve out this very narrow exception. So I think other states, though, don't necessarily have the same language in their mandatory reporting statutes that creates this conflict in the first place. I don't have like a 50-state review I can give you, but that's kind of where we started, was we looked to see what other states with statutes that were similar to ours had done, and then tried to craft that exception the way that they had done.
Thank you, Madam Chair. One follow-up. Okay, so let's say that this goes into effect. Do we run the risk of there being victims that then are not able to seek justice?
I believe in the context of this, I think this goes back to the statements that the social worker from the federal defender talked about a lot of times what we're talking about here for the most part are going to be circumstances in which the information is often historic and already disclosed in other contexts potentially, or to other individuals, but maybe additional details about the circumstances might be incorporated in the conversations that are happening with the defense attorney in that circumstance. And so the risk there is, I think, less than you would normally see, but it certainly is possible that there would be a disclosure that might not be otherwise made in other contexts to the attorney, but that disclosure could be made directly to the attorney, and that would not be reportable by the attorney in this circumstance anyway.
Thank you, Madam Chair.
Representative Vaughn.
Thank you, Madam Chair. Thank you, Ms. Cessna. My question is similar in nature. But so, we talked about how in these instances, usually the events are historical in nature, or the person's in custody so they don't pose a threat, or, worst case scenario, they would be covered by the ethical obligations of the attorney to, report something if someone's in imminent harm. But I was just trying to think of other types of scenarios, and wondering, if something was concerning but subject to this confidentiality clause, would the social worker and the attorney be able to work together to get that individual in potential harm assistance? And then I guess one scenario I was thinking about is, for example, if a mother is in jail and the mother discloses that the father, who is not in jail, may be abusing or neglecting their child, would that be reportable? Would they be able to get that child help since the mother or the father is not the client? For example, I know these are scenarios that are probably, or it's a very small group that I think would not fall under the 3 mentioned exceptions, but I just, was trying to think about that in practice.
So your initial okay, so obviously without having sort of the very, very specific circumstances, the answers are definitely going to be very case specific as to the context in which the disclosure is made, who else may have been present for the disclosure, because client confidentiality would only extend to members of the defense attorney and their team. So for instance, if somebody else was in the room from the jail, that may not always qualify as confidentiality. So there's a lot of context there that I think on a case-by-case scenario would really make a difference. I think the key here is that because of the language of when under the supervision of an attorney, it requires basically that the attorney provide some oversight over that social worker before any kind of disclosure is made, to ensure that if that disclosure is being made, that it's not violating those confidential requirements. So it's hard to give a specific answer to without sort of all of the context of details that can play into that, because there's a lot of very specific scenarios which could really materially affect whether or not this violates that confidentiality requirement. So I'm not sure that I can necessarily give a completely yes or no answer to that question, but
Could I add something, please? Heather, do you mind? This is Jim Pratt.
Yep. Thank you. Go ahead.
I would just like to say that the ethical rules do have a basically crime fraud exception, where ethically we cannot help a client commit a crime or perpetuate the crime so to speak. So if there is something where it is an ongoing situation, then we may be ethically required to report that. And that would, of course, extend down to anyone that we work with. They would consult with us, and then we would probably call the disciplinary administrator's office and get some advice from there. But yes, there is that exception where if it is an ongoing crime, that we may be required to report it as well.
Thank you. That's really helpful. I think that addresses my concerns. I think that would cover most situations. And I can see where holistic defense would be really important for defense clients. So thank you. Thank you, Madam Chair.
Committee, any other questions? Okay. I will call your attention to the written-only proponent testimony, Dr. Tim Davis, Michelle Ewert, Courtney Ellis, and Becky Fast. And not seeing any opponent testimony or neutral testimony, I'll go ahead and close the hearing on Senate Bill 128. Okay. Thank you, everyone, for being here. We appreciate it. And we'll move on to Senate Bill 156 and ask Jason Thompson to go ahead and give us a brief on this one. Thank you.
All right. Thank you again, Madam Chair. Jason Thompson, Revisor's Office. Senate Bill 156 yet again comes to you via the Senate Judiciary Committee and passed the Senate 40-0. This is a bill that creates a new crime known as unlawful use of a laser pointer. So this new statute would provide that unlawful use of a laser pointer is knowingly directing light from a laser pointer at either a law enforcement officer while that officer is engaged in the performance of their duties, or at an aircraft in flight or the flight path of an aircraft. So there's two different components that could be met there. The penalty for violation directed at a law enforcement officer is a Class A person misdemeanor, and the penalty for directing at an aircraft is a severity level 9 person felony. The provisions of the section related to aircraft do not apply to a person authorized by an aircraft manufacturer or the Federal Aviation Administration to do research and development or flight test operation while doing their job, basically. They are exempt from the crime. Laser pointer is defined. It means a device that emits light amplified by the simulated emission of radiation that is visible to the human eye. So pretty specific scientific definition there. And we note in the second to last subsection that a person who violates this section may also be prosecuted for assault or battery if a threat or harm actually results. You could be prosecuted for those additional crimes if the elements are met. And it would take effect on July 1st if adopted, and it would be part of the criminal code, obviously. I think I mentioned that. I'd be happy to answer questions.
Okay, committee, do you have any questions for Jason? Representative Schreiber.
Thank you, Madam Chair, and thank you, Jason. Are there federal laws now that prohibit that use of laser pointers at aircraft?
Madam Chair, is my understanding, yes, there is. I'm not as familiar with those, but I understand that there are federal laws on this subject.
Thank you.
Okay, anyone else? Seeing none. Thank you, Jason. We appreciate it. Oh, I'm sorry. Representative Carmichael.
Appreciate your patience, Madam Chair. Returning to that subparagraph E at the bottom, a person who violates this provision of this section may also be prosecuted for, convicted of, and punished for assault and battery. When we're talking about the same conduct, I pull out my laser pointer and I point it at you. Would this allow the prosecutor to charge me with 2 crimes for the same act?
Madam Chair, Representative, potentially. So usually you have to have that additional element, right? So the idea, we do this in a few crimes where we say this conduct may also be punished as this other crime. And typically it's, in the battery one is the more obvious one here, right? If I shine the laser pointer at a law enforcement officer, I've committed this crime. But if I also happen to damage their eyes, I've committed battery as well, because I have harm on top of the pointing of the laser pointer. I think that's the idea. The assault one I'm not as clear on, but I know we have assault or battery on some of these similar crimes. And so maybe the proponents kind of explain why they want both. But I will say this language is typically used, and again, it still requires you to have that element of the offense and be able to sort of prove both offenses. Otherwise, you end up with a more specific offense, rule of lenity issue.
That's all what I was thinking
Yeah, yeah.
through and getting rapidly confused.
Yes, it can get very confusing, and again, not a prosecutor, it would be up to the prosecutor to kind of show how you could actually charge both of the offenses, that they don't overlap, that the less, the more specific offense with the lesser penalty doesn't apply, and you can't charge the higher penalty, right? All of those are in play, and that's why prosecutors are good at what they do, and I do this, so I'll stop.
Thank you, and you do a great job. Okay, thank you. Great. No other questions? We'll go ahead and we have proponent testimony from Sage Hill from the Kansas State Troopers Association. And I think we have a video to watch. I mean, first, maybe Sage, can you hear me?
Madam, I can. Can you hear me okay?
We can't. Yes, there you are. And we can see you too. So, yep.
Good.
Go ahead.
Okay. I'm Sage Hill. I'm the president of the Kansas State Troopers Association. Thank you so much for having us here to talk to you all about this. I know you do have quite a bit of written testimony on this, so I'll let it largely speak to our buy-in on this proposed legislation and just mention the wave tops. I know you guys have done a lot of business already today. And diving right in to address some of the previous questions, that is specific to more traditional law enforcement functions on the ground. That is one of the biggest issues for my organization, is that these laser pointers are very commonly associated with the aiming devices on modern firearms, right? So it's a totally logical nexus for any officer, whether that's a trooper or a game warden or a sheriff's deputy or a police officer. If they're out handling a call, interfacing with the public, and they look down and there's a laser pointer, coming off the ornaments on their uniform or the equipment on their vest, it's a totally logical thing to think that there might be a gun on the other side of that. And it's an immediate escalation of the situation. And unfathomably, in the state of Kansas right now, absent another crime, that's actually lawful conduct. Even though I cannot think of a scenario where you would do that without nefarious intent, point a laser at a cop on a call, you can do it absent any other crime. There are laws, there are federal UCRs that deal with it with aircraft, and that's actually my day job with the Highway Patrol right now. For about the last 5 years, has been as a pilot in our air support unit. We see it very frequently. In the last 5 years, I've probably been on board our aircraft 15 to 20 times when we've undergone laser strikes. I can speak to that to some degree if anybody wants. But I would say over half of those have been in the last year. So the trajectory on as far as frequency is on the uptick. I just had something sent to me from the FAA that I can have our office forward to all of you. There were, in 2024, I think there were 154 strikes in Kansas, which is pretty high, and there were 12,000 some nationwide. And it does, again, I speak from experience when I say that it can create an incredibly hazardous situation in the aircraft. So yeah, both are a problem. The federal crime of doing it, it's not arrestable. Again, absent another offense, it's not arrestable for our local officers at the street level. If that's the only thing they see, they're empowered to gather a person's individual information. They can seize the laser, and then it's just being referred to the feds. And we deeply value those partnerships, but that is a highly complex process that involves, seating a grand jury, going through that whole indictment process. There's civil proceedings with the FAA that take place, and there's just not any expeditious tools that we have to deal with the situation at hand as law enforcement officers in Kansas. And Kansas is kind of a standout in that regard. I don't think there's very many states that lack this legislation. So with that, I'll hang out and be glad to answer any questions whenever you all wrap up.
Okay, thank you. And are we able to load the video now? Okay, let's do that. Okay, so Sage, can you explain what we're seeing?
Yes, ma'am. So this, I believe, is a call that I was actually the flight officer on. I don't want to misspeak about which call specifically it was. Um, is there an audio overlay on this at all? Do we know that'll come in, or is it video only?
We are not hearing any audio. Are we able to get audio or not? No, not now. Okay.
Okay, that's okay. So I'll just kind of talk through it. I
Okay.
don't know which call specifically this was, but I can tell you anecdotally, the worst one of these that I've been through. This is a decent. If you see right there how the laser completely flooded out the camera, that's similar to what happens to our eyes. And operating aircraft at night, we very intentionally leave ourselves conditioned physiologically for total darkness, right? So we can see those faint references to the horizon, small obstacles, other aircraft. We need to be able to have that conditioning for almost total darkness, down to whenever we're doing a pre-flight, we use red flashlights. We are in the dark, and whenever I think it was whenever I spoke to the Senate, I gave the example of you get up in the middle of the night, you flip a light on, not thinking about it, and that's not just uncomfortable, like it's actual pain and kind of disorientation that you can experience from a light bulb that you're used to in your house, just whenever you've been sleeping, and that's kind of where you find yourself whenever you're used to the dark. This is one of the most intense light sources on the planet, literally a laser beam flooding in the side of the aircraft when you're usually, for us doing low level tactical orbits and stuff, we're already in a turn, we're in the air, and you might have one eye that is completely conditioned for darkness still, and the other that's been just flooded with a laser. So your equilibrium is off. It creates a very hazardous flight condition. It's easy to get spatial disorientation and think that you're straight and level when you're actually turning. We've been lucky that we haven't had a bad accident caused by this. This, I think, this was one in Wichita where the officers ended up contacting these individuals. They were not able to make an arrest on site, but they were shining their laser at our aircraft while we handled another priority call with the Wichita Police Department because they thought our engine noise was annoying and disturbing.
Okay, thank you. I know there are a couple folks from the state troopers here in the audience. Is there anything else you'd like to add to the video that would be helpful for us to understand? Nope. Okay. Okay. Thank you. Okay. Do we have any questions for Sage Hill? Any questions about this? Representative Barth.
Thank you, Madam Chair. And thank you, Sage. The video is a little bit hard to see, but it looks like it's a green light. Is there any specification of the color of the laser? Does it matter, what that laser looks like? We have a lot of blinking red lights from wind turbines across the area that has to be distracting. So can you, when you're talking about pilots and planes, and you laugh about that, it's not really probably very funny, right? So, but a lot of us, we had a bill that was supposed to have all those new wind turbines not have those lights, but we have issues for aircraft in Kansas. So if you could tell me a little bit more about the color and things like that, that'd be helpful. Thank you.
Yes, ma'am. I've seen red lasers, green lasers, blue lasers. By definition, if they are an actual laser, the color's really not going to matter to us. It's just going to be a super intense bright light, and that's why whenever the video scans over to color mode, that's whenever you see the light. This is an infrared image here, so it's thermal. Now we just changed the filter over so that you can actually see the light. Whenever it shines in there, like right there, all you see is the laser because of that intense beam just overloading the camera system, which is almost exactly what happens to our eyes. So the color doesn't really matter, it's the intensity. And some of these are so powerful that you can buy them from mainstream, off of Amazon or whatever, and you can start fires with them. If you're close enough to whatever you're shining them at, they will they'll light stuff on fire.
Representative Williams.
Thank you, Madam Chair. Sage, I wanted to ask you, just so for clarification on my end, you also talked about a laser pointer at police officers kind of like escalating the situation too when it comes to not knowing if you're in a pursuit and that person has a firearm. Is that correct?
Absolutely, absolutely. And in fact, one anecdote that I would tell you that I'm personally familiar with was it was just a college party. That a handful of officers, there were some troopers that were going into it to assist a handful of city police officers. That it was literally a college party that was just a little out of hand. But they were just going to tell them, hey, turn your music down. You're starting to bother people. And maybe think about shutting it down for the night. And in the midst of that benign of an interaction, one of them looked down and they were being painted with a laser. So they didn't know if there was somebody in the crowd now that's got a weapon that they've introduced to this situation. But it immediately took that from something that wasn't a big deal to a pretty big deal. And it's not unusual. We see it quite a bit, especially in the metro areas.
Thank you.
Hey, committee, any other questions? Representative Carmichael.
Thank you. I'll make this in the form of a question for the trooper, but I certainly understand there's danger shining lasers at aircraft. I've never got flashed that I know of, but it's something I wouldn't want to have happen. And I know it's dangerous to put the dot on a law enforcement officer because they're going to react badly too, as they should. But I've got to tell you, I know a lot of people, I've been known to carry firearms, and I've had laser pointers on firearms that I've owned, and I don't respond very well to somebody putting the dot on me in the night either. And I'm just kind of wondering why we only afford this protection to law enforcement officers, because I think anyone who finds a red dot on their chest is going to assume that someone's getting ready to shoot them. Now, that's my observation, and nobody needs to answer. I guess I've made my point.
Thank you. Okay, any other questions? Representative Barth? Yep.
Madam Chair, thank you. Quick question for you again, Sage. You mentioned the lasers that could start wildfires, or not wildfires, but could start fires. They're called DEWs, and I looked it up. It's the directed energy weapons. Do you have any, are there any known cases of that, or is that just, it's a known risk? Thank you.
It's just a known risk. I know for researching this project, when these conversations were going on, we were trying to talk about well, how big of a deal is it? And yeah, I mean it's an advertising function now for a lot of these manufacturers that their laser is so powerful that you can with dry leaves or whatever, if you hold it down there, it's the old magnifying glass in the sun trick for long enough. But within seconds, I mean they're melting things that it's just kind of demonstrative of the intensity of these devices. Now they've got them to the point where you can, one that'll fit on a keychain is bright enough and intense enough and hot enough that it'll start fires. But as far as like any issue that specifically posed for us, especially here in Kansas, I don't know of any. No.
Okay, Representative Barrett.
Thank you, Madam Chair. Just real quick, Sage, thanks for coming to committee. From what I've heard, and again, same as the representative from Wichita, I haven't had it happen while flying, but I've had other pilots who I know said that just when the laser hits that windshield, it reflects across the entire windshield and just creates that blinding light. So what could be a little $3 laser is just from that distance blinds the pilot completely. Is that correct? Can you confirm?
It is. It is. Yeah. And the worst one that I've had, we were up for a patrol flight. There was unfortunately a drive-by shooting where a 15-year-old victim was struck in the head. So a priority call, we get overhead. We were assisting the officers, and my partner, Ryan Tower, excellent pilot. He was actually at the controls of the aircraft. I was in the back. We were in a fixed wing. So we're in an orbit. And he looks up visually from the pilot's seat and he sees a car a couple blocks away that just didn't look right to him. So he asked me to check it out with the camera. I do, and we saw people not only kind of surreptitiously observing the officers at the initial call location at the drive-by where the kid got shot, but then we see them hiding guns and stuff in their trunk. So okay, this is a priority deal now. We have reason to believe that they're involved. Direct officers over to them. And a pursuit took place. There was a use of force. After the pursuit ended, they took off on foot, and then there was a fight involving the officers. So I say all of that to say it was an important call that we were playing a really key role in. And over that final location where the foot chase and the fights and all of that was going on, we got hit by a laser. And the laser, it missed Ryan in the front of the aircraft, but it came in the back of the aircraft and hit me. And that's what I was alluding to earlier whenever I was talking about one eye. You know, we're in total darkness. I didn't get it in both eyes. I got it in one eye. And I'm glad I wasn't flying the aircraft, because it would have, you know, we would have automatically had to leave, just go wings straight level, and probably put it on autopilot and just reset completely. But as it was, it took me off my responsibilities as the flight officer on that mission, because I couldn't even look at our camera screens and our computers and stuff and do what I needed to do for several moments until I got myself kind of recentered equilibrium wise.
Thank you. And so, I mean, just like when it comes to trying to get your night vision back, that takes what, 20 to 30 minutes to probably regain that full night vision, correct?
Yeah, to get it back to where you started, for sure. We get through it, and we do the best that we can, but it is a hazardous situation to be in, for sure, and it takes a long time to get reset to darkness. You're absolutely correct.
Thank you, and thank you, Madam Chair.
Yep. Okay, committee. Thank you. I think we'll go ahead and welcome Ed Klump up to the podium for proponent testimony. Thank you, Ed, for being here.
Thank you, Madam Chair. Committee members, Ed Klump, Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. Not a lot to add to what's been said here already. This started years and years ago with the cheap lasers being shined up at police helicopters. We had a lot of that happen in Topeka when I was on the police department there. And it's kind of advanced with the advancement of the technology, making a much stronger beam of light than they used to be. And then in the past, 5, 6, 7 years, we've had a big increase in these lasers being used at very close proximity in demonstrations and disturbances, tactical operations, and things like that. And of course, the closer you are to that device, the more intense that beam is. And so in my testimony, I did put in the middle of that, you'll see that section with the bullet points. This is information from a U.S. Air Force research study, and it kind of states what the various ranges of injury you can occur from these lasers, from just a simple distraction to retinal damage. And, you know, the closer you are to those. And so as a result of all this, one of the recommendations now with tactical gear in law enforcement, that officers be equipped with laser protective goggles that they wear so they don't get injury with that. And that's kind of a new thing. It's not been implemented everywhere, but those are out there readily available now, and there's a lot of tactical teams that are using them. The federal law that we've been talking about is 18 U.S.C. Section 39A. I think this bill looks eerily similar to the language in that. I would imagine it was fashioned after that. We think it's a good idea to replicate that in state law, because sometimes these cases are more readily prosecuted in the state courts. And the way that works when we have a law in the state law and a law in the federal law is generally the state prosecutors, federal prosecutors get together, look at the totality of the case, history of the individual, and decide where it would be properly prosecuted at. And then by mutual agreement, they decide which way they're going to go with that. So, Madam Chair, I think with that, I'll just, I think Sage and all of your questions pretty well covered everything, and I'll stand for questions at the proper time.
Thank you so much. Are there any questions for Mr. Klump? Okay, Representative Vaughn.
Thank you, Madam Chair. Thank you, Mr. Klump. I was just reading through the neutral testimony, and they had some concerns about the fact that aircraft isn't defined. I guess it's not defined in our criminal code at all. I was just wondering if it was, you know, I could maybe work with you or the other conferee to come up with a definition that would capture your intent. I think the concern is, like, does it also include drones? Does it include things that fly that don't have a human who's operating that machine, that kind of thing? Would you have thoughts on that?
Well, I will point out that the federal law doesn't distinguish between aircraft for the purpose of this statute and the aircraft definition in federal law. And federal law does include drones. I don't know if that harms anything to leave it out, but I mean, that is the definition of aircraft. We do have some aircraft statutes. I don't know if we've got a definition in those or not, but the federal law certainly has one.
Thank you. I wonder if the concern is just like if a laser pointer is used on a drone, does that really rise to the same level as, the examples that we've been given today? But I think it's also a good point that it's probably a good idea to be consistent with federal law around these regulations. So thank you for answering my question.
Representative Goddard.
Thank you, Madam Chair. Nothing was mentioned in the bill, but has there been any body of thought since felons, it's unlawful to possess a firearm? Is there any body of thought that looks at felons possessing lasers?
Not that I know of. I think, we want to focus on the action here. There's things that lasers can be used for beneficially. And, I just don't think that we're ready to go to that step of recommending that we make them illegal for a particular person to possess unless it would be somebody who's been convicted of this crime once. That might be something to think about.
I guess something would have to happen in order for that to happen.
Probably.
But I agree with you. I mean, lasers are useful. A laser level for leveling paintings and all that kind of stuff, or a little pen laser to play with your cat. So okay.
With a warning.
As long as you don't strike the cat with it. Thank you, Madam Chair.
Thank you. Okay, seeing no more questions, thank you. We appreciate it. And written neutral testimony only from J. Houston Bales from BIDS Legislative Committee. Okay, committee, seeing no other neutral or opponent testimony, I'll close the hearing on Senate Bill 156. And just remind you there will be an addition to the agenda for Thursday. Be looking for that. That's something referred to us today. I especially want to thank Representative Brownlee Page for stepping in for Representative Martinez. Welcome to Judiciary. I hope you found it somewhat interesting. Yeah, and so just make sure you're looking at the agenda. And again, every day the agenda says possible action on bills previously heard, so just be aware of that. I don't have a list right now of what we might do tomorrow or the next day, but we're just kind of taking each day as it comes, see if there's amendments, see how we can fit everything in. That's what I'm trying to do. So, okay, thank you. With that, we're adjourned.